Hi, I'm Peter Tragos, host of the Lawyer You Know podcast and YouTube channel. The saying goes, everyone hates lawyers until you need one. Well, I'm here when you need one to answer your questions and give you insight that you didn't know you needed. Along with my partners, Pete Sardis, the professor, who has a finance and business background, and George Tragos, my dad, and the Conciliary, a criminal defense giant, we can answer any questions you have. What's up, everybody? We are back at it today talking about the Courtney Clenny case down in South Florida, OnlyFans model, charged with second-degree murder, claiming self-defense, and that is she is not guilty because the alleged victim was the aggressor and she reacted, which caused his death. So it's going to be an interesting legal discussion and fight throughout the case. But there was a hearing yesterday because her lawyer is doing everything he can to block the media and try to keep the media out of his case. And this has to be stemming from cases like Rittenhouse, Johnny Depp, even Curtis Reeves to a lesser extent. So we will see what kind of arguments he makes, what kind of arguments the state makes, and what decisions, if any, the judge makes. I don't know if the judge actually makes a decision or if she takes it under advisement, because I have not watched this hearing yet. We will watch it for the first time together, as we usually do. It is a little bit longer. The defense attorney filed something electronically, and some courts, it was actually funny in the beginning, don't actually get what's electronically filed, and lawyers have to bring a hard copy. He did not bring a hard copy. He apologized to that. The judge took a 5 or 10 minute break to review that, and that's where we're going to pick up on the hearing. We are also going to be listening to it on 1.25 speed so that I can be done here with this video by my next appointment. So I apologize if anybody gets frustrated by that. It's barely noticeable. I usually listen to it on 1.75 or 2 times speed. If any of you guys listen to me on 2 times speed, good luck with that, because I think I talk pretty quickly. Maybe 1.5 speed is a good speed to listen to me on, but let me know in the comments if you do listen to me on a sped up version, which is fine by me because that's how I listen to just about everyone. And really quick, tonight, 9 o'clock, fantasy football draft, Lawyer You Know League. We filled it up. It is a 20-team league. If anybody's not familiar with fantasy football, that's a huge league. It's going to be big. It's going to be deep. It's going to be fun. So if you're in on that, that'll be fun. 9 o'clock Eastern time tonight. If you haven't subscribed to our channel, please take a second and subscribe. And let me know what you think in the comments and in the live chat. When we talk about blocking media from certain trials and certain things in the trial, do you have any different feeling on a case that's in the criminal realm like this one, or like Rittenhouse, or even Murdaugh? They're blocking a lot of things in that case, or trying to, versus a civil case like Johnny Depp, where they're choosing to be in the court system. It's a little bit different. People's lives are not necessarily on the line. I should say their liberty and their freedom is not necessarily on the line. So do you feel any sort of difference if it's a criminal case versus a civil case based on what should be allowed to be viewed and seen by the media? Let me know if you have any difference of opinion, or if you think it's exactly the same in civil versus criminal, or you can let me know by saying more media involvement and allowance in a civil case, less in a criminal case, or vice versa. Whatever you believe, let me know. Brianna said it just doesn't matter. She feels the same. Do you feel like Brianna and everyone else that it should be totally open, or is there certain things that you think the media should not get their hands on? So with that in mind, let's take a look at this hearing and let's listen to the arguments that the OnlyFans, Clenny, I want to say her last name is Clenny. I keep calling her the OnlyFans model, which I hate doing. I want to call her, I think her last name is Clenny, but my mind blanks every time it pops into my head. Yeah, Courtney Clenny. Okay, there we go. All right, here we go. Let's listen and watch together.
Yes, Judge, just to put this kind of in context, we're here on the defense motion for protective order because of the influence that media can have on the fair and impartial administration of justice in this court.
I also am going to pause. The audio is not great on the actual video from the courtroom. So just everybody be aware of that. The audio is not great. We'll get through it together.
In order to provide for fair and impartial administration of justice for Ms. Clenny in this matter, we're requesting that Your Honor issue a protective order limiting the amount of discovery that would become subject to Chapter 119. We believe that this State Attorney's Office, beginning the day after Ms. Fleming's arrest, mobilized the media and utilized them as a tool. It's clear that the family of the decedent in this case also did the same. At a news conference the day after Ms. Fleming's arrest, put forth by the State Attorney's Office, where the victim's family was present, where the victim's attorney was present, and was given access to the State Attorney's news conference at the end after Ms. Barger was done speaking. The most poignant part about that State Attorney news conference was the release of an elevator video that depicted a physical altercation between Ms. Clenny and Mr. Blvd. In that video, which has been disseminated by millions now and edited, it's not, the State Attorney put it out without any context. The beginning of that video shows Ms. Clenny trying to keep Mr. Blvd from getting onto the elevator. It's important to note that that elevator also goes directly to that apartment. But why is that important here? The drip, drip, and drip of release of video in this case, or audio, pictures, pornography, is going to erode our client's right to a fair and impartial trial down the road, guaranteed by the Sixth Amendment and the Florida Constitution. All
right, so let's take a second. Sorry if I'm blowing your eardrums out. I tried to lower my mic a little bit because I know this is a little low, and I can lower it a little bit more. It's never going to please everybody. But he says that exactly what I kind of argued, which is the state attorney playing that video, which is not a video of the crime, could potentially poison the jury pool. And yes, this is the defense lawyer. And his arguments make sense, especially when he takes it to the next level and saying the state played this video out of context. There was a beginning part of the video where she tried to keep Mr. Obumseli, the alleged victim, out of the elevator. They were having a fight. She was obviously trying to leave. He followed her into the elevator. There's a lot of context, and we know that. Taking anything out of context, a video, a picture, anything out of context is not what we want, and it's not how we want to drive how everyone looks at this case and thinks that she's guilty before we even hear her defense. Now, it doesn't look good for her, and we're allowed to look at all this context and see and start forming opinions and things like that. But he's right. That's why we don't want either side just throwing evidence out against the wall for everybody to hear, especially the state attorney's office who's supposed to be searching for justice. They shouldn't be doing that at their news conference, announcing that they're filing charges against her, saying what the coroner said. You know, again, not knowing if that's going to pass muster and whether or not there's going to be a Dauber challenge, if that person can even testify as an expert. Now, they probably can, but I just think that he has a point as the state attorney's office, and I really bring it back to Making a Murder. If you haven't seen that, what that state attorney's office did to Stephen Avery, who may very well may be guilty, but what they did to him in the media, pre-trying the case and getting everyone against them, regardless of what actually happened on the night or day in question, is problematic. And he's about to say, you know, the pornography and the nude photos and videos and things like that, that they're going to continue to drip and leak. That's what he just said, the drip, drip, drip of pornography. That's just making my client look bad. It does not tend to prove or disprove whether or not she committed this crime. And that's the point. If there was a video of the crime, that's different. But that's not what we have here. And that's what he's trying to block. So that's interesting. Stace on the case says, I'll wait until the end of the trial. Good point.
Now that Rule 2.420 of the Rules of the Judicial Administration talk about the power that the court has, as outlined in my reply, and subject obviously to the Lewis test. We have to show that there's no other alternative other than seeking some type of closure, and in this case, a partial closure. The defense submits that we have met the burden by using the attached affidavit, which we submit to the court's evidence in this matter, and that is the affidavit of Michael Haas. But I'd like to go back. Before becoming a public record, let me back. It's clear. Once the state turns over discovery to the defense, it becomes subject to Chapter 119, which has its own built-in exceptions, one of them being protecting the interests of third parties. In some cases, the defense confessions are protected. So these things would be redacted, and we'd like to hear from the states how they would plan to redact those items. But as a threshold matter, under the Rules of Judicial Administration, Your Honor has the power and the discretion, as indicated by the appellate courts. It's in the sound discretion of the trial judge to grant or limit criminal discovery. And that's State Constance 643, SO2D 1172, and that's a third DCA case out of 1994. The rules of judicial administration allow Your Honor to issue protective orders for discovery. Clear, black and white letter of the law. It's done very often in federal cases, more so to protect government procedures, investigative techniques, but it is done very often more so in federal than it is done in state. Why is it so important?
So Chapter 119 is just public record. So once it becomes public record, media can get it. They can put it out there, especially if the state is calling the media to press conferences and leaking stuff to the media. It's all subject to that. But the court does have discretion to basically block what the media can get and what the state can make public record.
Here. The Miami Herald, in their response to my motion, put forth some numbers about how many website hits that were related to the article concerning the elevator. And they're like 4,000 here, 4,000 there, 2,000 here on their articles. Just on their articles. And no offense to the Miami Herald, but they're not a nationwide publication. Those numbers are very small, I think. But we don't live in the golden era of the Miami Herald. We don't live in the golden era of any kind of print magazines or print publications anymore. This is publication by immediate release, and this occurs over all kinds of websites, all kinds of social media platforms, and that's the world we live in today. One tweet, you hear it all the time, it goes viral, and it's got millions of retweets and this. Their numbers saying that, oh, we're not affecting anything here. We want to access freedom of the press to get all this discovery, which will contain salacious materials. They want it all to bump up the click, ka-ching, which is the money, the revenue that they're driving through the clicks to their site. That's the motivation here for the Herald, to intervene. It's not to protect the public, freedom of the press for the public. They need clicks. That, when we're countering the weight and the influence that this will have on Ms. Clenny's trial down the road, her right to a fair and impartial jury, which I submit to the court by the state already releasing that video, has already elongated the jury selection process by days. This continued drip, drip, drip of information.
So a couple of things he said there. First off, the media outlets have their own lawyers that file motions to try to protect this, to make sure they can get as much as possible. And he's saying what they all argue, because we've had these motions in some of our cases, especially in federal court, which he mentioned, they block a lot more from the media in federal court, but they still try to get in. And they always say, you know, the public has the right to know this, the public has the right. And he's saying they're not doing it for the right, they're doing it for the clicks. And he talks about how many clicks they're getting and what attention they're getting, how the Miami Herald's no big deal. And now this is becoming a big deal for them. So he's making some decent arguments there, even though in state court, it usually does not, they're usually not winning arguments.
Coming through the discovery, which is—
Oh, he also makes a good point that if we deal with all this media attention, it's going to add days to jury selection and days to the trial and make it much more difficult and potentially even a change of venue.
listed, there's thousands of photos. They did a cell phone download of Ms. Clinton's phone, which is going to contain hundreds, this generation, hundreds, probably thousands of text messages. It's also going to contain content that she would use on her OnlyFans site, which has nothing to do with the events of August 3rd, 2022. I'm sorry, April 3rd, 2022, when Ms. Clinton had to defend herself. It's going to contain, this drop of discovery I'm submitting, a terabyte drive to state, is going to contain personal text messages with her family, friends, third parties that have nothing to do with this case. And that's going to be subject to Chapter 119, and the media, through Ed Griffith and the state attorney's office, they're going to send links to the media. Here's your public records request link to this video. And it's going to contain information that is highly inflammatory, prejudicial, completely irrelevant, and would never pass muster to come into the four corners of this courtroom for Your Honor to make an evidentiary ruling as to whether it's admissible or not. That's what we're trying to protect here. The only way to do that, Judge, is to limit the release of this discovery. And what I would suggest is, and we've done this in other cases where the state and I and co-counsel, we sit down and have a discovery conference. We go through the discovery, hey, this is relevant, this is not, this is relevant, this isn't, we want this, we think this should be released. We'll come up with, to Your Honor, with as much agreement as we can about what should be subject to disclosure, what should not be subject to disclosure, to pare down the amount of discovery in this case, because it is voluminous by the state's own admission. So that is a workable plan. I think it's a plan that guarantees both freedom of the press. It guarantees Ms. Clinton's right to a fair trial, but we need some type of backstop to prevent the salacious release of videos, TMZ released videos, there's a hunger for this case in the media. And what we're trying to do is make sure that this case gets tried in a court of law. And actually, to quote Ms. Rundle, after her news conference, we won't be doing this in the media. This belongs in a court of law, and that's where we will go from here. From here, meaning after they release that video, saying that, oh, we think this video depicts the aggressive nature of this clinic, offering her own commentary, which, if you turn to the affidavit of Mr. Haas, sorry, Judge, forget I'm going.
Andrew, I haven't seen any videos of him hitting her if they do exist.
I apologize. I passed up to the court my only copy of the motion. I don't know if the state has the copy that they were going to provide to the board. I just wanted to highlight.
I would give it back. I just wrote on
No problem, Judge.
That's interesting. The judge is making notes on
Judge,
it,
what
so
we
she
did,
can't give it back.
To counter and present to the court what we believe is a more appropriate picture of the influence that release of these types of videos or conversations can have, and showing that the court that the affidavit provided by the Herald is completely off base. Mr. Haas did certain searches, which he delineates. He did a time matrix. The one popularity and trend of that video were trending at the highest point. The highest point was, I think, the day after this news conference by the state attorney. All right, he did all kinds of searches. The top 5 searches, when he searched for Courtney Taylor elevator, 933,000 views. And that consisted of 292, 293, 237, 60,051 all coming together. And then he has the snippet or the screenshot of how he conducted these searches. Again, using the same method, in the search term Courtney Instagram elevator, 634,000 views. And Your Honor can read the rest of it, as I'm sure you did. This isn't 4,000. This is millions. Millions. Now, what I can't tell Your Honor, I don't know where these viewers were, but I do know that this video is, and that was last week. So these numbers could be increasing. Every time there's going to be a drip, drip, drip of release of information through Chapter 119. If Your Honor doesn't grant this protective order, you're going to see these same spikes. Oh, video released of Ms. Clenny talking to Mr. Ubamselli days before. This case needs to be tried in this courtroom with the protections that I know Your Honor will give us to a fair and impartial trial. Jury, and under the rules of judicial administration, a fair and impartial administration of justice. That's why we're here, Judge. The influence that the release of these irrelevant discovery materials will have on her constitutional right to a fair trial. Thank you, Judge.
Thank you. Anything further, Mr. Pierre?
All right, before we hear from the state, let's get to some questions. Linda Laferriere is a new member, and Sherry D is also a new member. If anybody wants to join the membership, the link is in the video description. You can just hit join. Wendy Zielinski, how is a Daubert challenge applicable? The state in their initial press conference said the coroner said that he was stabbed with a descending blow, couldn't have thrown the knife across. When you start spouting off what your experts say before the judge has ruled on if they can even testify, if they pass Daubert muster, now again, they probably will, but that's why you don't state evidence as fact as a prosecutor in the media early on in a case. And that's the issue he has, is they're trying to pre-try this case. They're trying to color anybody that could potentially be in the jury for this case. Brianna, I have no idea. I have never heard of either of them prior to this case. I don't know if he was also an OnlyFans guy or whatever. Karen, who decides how long the trials go for? Usually so there's a pretrial order. The lawyers will talk to each other, how many witnesses they have. Based on that, how many days they will need for each of their cases. The state may need 5 days and the defense needs 2. They need 2 days to pick a jury. That means it's going to be a 9-day trial. They go to the judge, say, Judge, we need 9 days. Judge sets it for 9 days. The judge can theoretically change it, and there are limits, and they can, pick whatever they want, but usually they defer to the lawyers on, especially a defense lawyer. You're never going to cut off how many days a defense lawyer needs because his clients have constitutional rights. What is the instinct of the chat? Arnaud said, guilty or not? I really hope everybody in the chat says not guilty at this point, because she is presumed innocent in our country until she is proven guilty in a court of law. Brianna, so she's alleging he abused her. Yes, absolutely. That is her defense, that this is a self-defense case. He threw her across the room and was abusing her when she threw the knife, and he ends up dying. Deborah, Peter, do you think the elevator video is important in this case? I do, for a number of reasons. Number one, everybody seems to have already picked a side based on that elevator video. Number two, I think it will still come in as evidence to show her aggression, to show that she was abusive, to show that she has this in her, especially if they're saying it was self-defense and how he didn't hit her. And the actions and conduct of the alleged victim can sometimes become relevant, and things like this can become relevant in a case if she is claiming, the defendant, that the alleged victim is actually the abuser. Then their aggressiveness and their personality and how they act and whether or not they are abusive can become relevant in the case. So I think it can, but I don't think it's appropriate for the state to play it and act like it shows the murder, which is almost what they did. I do not know the judge future. She does seem very professional. Audra, hi, Peter, female defense counsel. So I think that's her right here in the with the red blouse. Is the lawyer that introduced me to your dad. She's my BFF. Did you see the picture I took with your parents? I did. I thought we posted it on social media. Audra met my parents at a Florida Association of Criminal Defense Lawyers annual meeting this year. I believe it was down in South Florida. I was not there, but I did see the picture. It was awesome. And that's what a small world, right? Who knew we'd be doing a video with 1,000 people in the chat with your BFF on it that introduced you to my dad. Pretty cool. Yes, Pooh Bear. Also, check out the Lawyer You Know merch, people. Yeah, and we've got some new merch that's going to be coming soon. That's in the works. Amy NL, thank you so much for joining. CMC, do you think there's anything else he should have argued? I mean, I really think it's a tough argument because there's a lot of things he's going to be able to keep out of the trial, I think, because they're not relevant with her OnlyFans page. Some of it is going to be relevant, like what she was posting right after the alleged murder to show her mindset potentially. But I think it's going to be tougher to keep this stuff out of the media, especially because I don't know this to be true, but some people probably have already downloaded her OnlyFans page, if that's something that you can do, like a Facebook page or whatever. And they probably are going to drip it out to get those clicks and get those views. So who knows? So Kaylee, please don't laugh, but what exactly is OnlyFans type of social media? Don't feel bad. I had the same questions. I think it is kind of like YouTube or TikTok, except that you can have adult content on there as well. I'm not sure what makes it different from just like a pornography site or what, but I think that you can have adult content on there. So like X-rated TikTok or X-rated YouTube, I guess. But I think there are people that maybe have legal shows or, bake stuff, or I don't even know. Deborah B, in my opinion, open trial to a non-biased media so that people can hear for themselves without cutting and editing of the facts. I don't know what that means, unbiased. Open trial, definitely open trial. I mean, once the trial is happening and the jury is there and they're not going to be affected by it, I agree. And anything that can come into evidence as public record, fine. But things that are discoverable that aren't even going to come into evidence because they're either not authentic or they're not relevant, for people in the normal world to make up their mind on things that are not even going to be evidence at trial, that's the tough one for me. That's the tough thing for me to swallow. Rich Cat Ranch. I'd love to see Peter a contender for a Streamy Award. I have no idea what that is. Please show him some support and appreciation by liking, commenting, subscribing, and sharing the channel and videos to help make that happen. Yes, definitely do all that. Even though I have maybe a Streamy Award is like for YouTube streamers or something. Are you on Only Lawyers? KWNY Upstate. I'm not on Only Anything. I'm not on Only Anything. All right, let's get back. And Sue, I do want to say thanks again for this sweet comment. You guys were all awesome and so nice. It was awesome to be recognized as the best lawyer in 2023. Appreciate you all. No, Azam, this hearing has nothing to do with what's admissible and inadmissible at trial. That's the tough part about this. It's just what they can leak to the media and what's subject to public record, which in Florida, we have a pretty broad and liberal public record rule where we want things to be public record. We err on that side. We err on letting the media put stuff out there and the citizens of our state having access to what's going on in the court system. Bodie, why do they call the judge the court instead of you? So it's an official title for the court or the judge to call them that. It's respectful. It's honoring for them as opposed to just saying you and being a little less formal. All right, let's get back to it.
Anything further?
No, Judge, that's the affidavit is the only
That
evidence.
this court rely on your motion in reply and the affidavit of Michael Haas, is that right?
That's correct, Your Honor.
And just for verification, this court's review of the affidavit of Michael Haas, it does not seem to address the geographic location of his research, correct?
That is correct, Your Honor.
Okay, unlike the declaration submitted by the Miami Herald, which does address the specific Tri-County geographic location of their research.
That is correct, and Mr. Haas attempted to garner that information to verify the local hits associated with those Herald articles, but that information was not accessible to him due to limitations and parameters set on the website that is controlled by the Miami Herald.
Thank you. Any response?
Yes, sir.
Who would like to go first?
I do not mind. I believe mine will probably be lengthier.
If he's gonna be lengthier, I'll be shorter. Your Honor, thanks for having us today. Scott Moss on behalf of the Miami Herald. I actually want to talk about.
So this lawyer represents the Miami Herald. And like I said, they always pipe in here because they want to make sure they can get access to this stuff for the public because of the best interest of the public. But sometimes it's about the clicks and they do make money off of this stuff, right? And so, it's always an interesting argument as to why they need to force their way into these trials. Let's hear what he has to say.
Well, the law requires. Now, I won't belabor the point because I think what Your Honor just said is very important, pointing out where these views come from. But the right of access to this material isn't driven by how many clicks there are, how many changes there are, how many drips there are. It's not a numbers-based analysis. There's no bright line that says it has X amount of views, maybe restricted. You have less than X, maybe you don't restrict it. Once the information is given, Mr. Prieto said this, and he's absolutely right. Once the information is given or required to be given to the defendant, it becomes a public record. And the way it works, logistically, that's the right way to say it, is public records request is made upon the state attorney's office. And the state attorney's office then complies with the public records request, claims exemptions that you should be claimed. That's how that works. So we get to the Lewis test. And the first part of the Lewis test asks, and that's what we're governed by here. The Lewis test asks, first, closure is necessary to prevent a series of imminent threat to the administration of justice. And that's the basket in which the defendant has put all of their eggs.
So what he's saying is the only way you block the media is if it's going to be a gross miscarriage of justice, basically. And he's saying that's what they're relying on. And now he needs to blow that argument to pieces.
And what counsel is arguing is the threat to the administration of justice is that absent closure, the defendant's right to an impartial and fair trial as guaranteed by the Sixth Amendment will be violated. I think it's important to at least say for the record, and it's cited in our papers, and we cited a couple of decisions, we could have cited 10 more, about what it means to have a fair and impartial jury. It doesn't mean a juror who has never heard about the defendant. It doesn't mean a juror who's not aware of the case. A fair and impartial jury, the Supreme Court has said this time and time again, and it's in our papers, a fair and impartial juror is someone who, even if they've heard about something, will agree to put aside any preconceived notions and agree to base their decision on the evidence that's submitted in court. That's what a fair and impartial juror is. So,
just for clarification, when he says things like it's in our papers, what that means is they've already filed motions with research and memorandums and exhibits. They've given those to the court. Those are the papers. This is the oral argument. They can reference the papers in their oral argument, just in case anybody was wondering.
So why did we come forward, Your Honor, with the numbers of readership, or number of clicks, as it were, of the articles and video in Miami-Dade, Broward, and Monroe counties? About 10 years ago, just like Mr. Prieto argued, about 10 years ago, we started hearing arguments from defendants saying, well, when Lewis came out and the other case came out, you had a newspaper of record in the county, and you had 3 network TV stations, and if you didn't watch the news or didn't subscribe to the paper, you probably never heard of anything. So now that we're in this world where there's the internet and social media and things like that, it's all out there and everyone will see it. And the reason for Ms. Whitman's declaration, again, the analysis is not driven by the number of clicks, but it's to show, God, I wish my client, I wish each of the 2.6 million people who live in Miami-Dade County subscribe to my client's newspaper, but they don't. And we submit the numbers we submitted in Ms. Whitman's affidavit to show that even if this were a horse race about how many clicks there are, there's just not that many locally. There's not. And the notion that in a county, and again, the cases, we cite a lot of cases for this, and a lot of quotes in our paper, the notion that you're in a county as large as Miami-Dade County, that you're not going to be able to seat an impartial and fair juror is just ridiculous. It's just not true. And that kind of segues into the second problem of the Lewis test, because again, the Lewis test is the test we're governed by here. The second part of the Lewis test says, no alternatives are available. I'm sorry, that's the word right there. No alternatives are available other than a change of venue, which would protect the defendant's right to a fair trial. And in the reply the defendant filed, I think it's about 4 lines, 2 sentences, really skipped over it. And this is a very important problem. In every trial Your Honor has ever conducted as a trial judge in criminal court, in every trial Your Honor did when she was an attorney before she was a judge, we use voir dire to weed out any juror who gives any suggestion that they can't be impartial for whatever reason. They're related to an attorney, they know the defendant. It's a coastline case and they love to go on cruises. You would do the same thing here, Your Honor, as you do in every case that's been in this court. You're going to see if anyone in the veneer gives any indication that he or she can't be impartial and base their verdict on the evidence that comes out of the court.
I always do my best to summarize what they're saying. Right now, he's basically saying they're arguing it's not going to be a fair and impartial jury. Well, guess what? There are people that are not fair and not impartial in every jury pool that we pick a jury from, but that's what we do in voir dire. We talk to the jurors, we try to figure out who's not fair and impartial for whatever reason, and we get rid of them. This is not going to create any excess of that. That's basically his argument now. And I'll continue to summarize it kind of as we go because it is a little bit low and I have it sped up just a little bit to 1.25 speed.
So on that basis alone, there's no reason that the plaintiff can't meet the test. And the third point, Your Honor, is that closure would be effective in protecting the rights of the accused without being broader than necessary to accomplish this purpose. And again, Your Honor, that kind of gets to what we've just been talking about, is that an order closing all of the discovery is much more broad than necessary. We have voir dire, we have admonition to the jury. Just closure is way too broad of I don't even want to say remedies. I don't think we're talking about remedies. It's much more broad than needed. And Your Honor, I want to be clear for the record whether I need to object to its admission on relevance grounds or whether I just will make argument as to relevance grounds. Mr. Haas's declaration is wholly inapposite and irrelevant for the reasons Your Honor pointed out. How many people around the world have clicked on this just doesn't matter because we're not the United Nations. We're not drawing a jury from around the world. We're drawing a jury from Miami-Dade County, and there's been no indication from defendants, and it's their evidentiary burden. There's been no indication to show the circulation of the views of any of these videos in Miami-Dade County. And
so what's tough about that argument, he's arguing that it's the internet, it could be from around the world, people could look from anywhere, is the burden is on the defendant in this case, in this situation, and they don't have access to that. So how would they ever prove that? I mean, the vast majority that read the Miami Herald probably is local. But when they see this case, maybe it does have a wider spread audience. It's interesting. I'm going to start looking at the demographics of my channel that watch this specific video to see if there's any more in Florida or in South Florida that watch this versus some of the other videos. My guess is no. It's probably the same couple thousand people that watch all of the videos that we watch together and break down together. But he's making a good argument, but at the same time, it's kind of disingenuous because, I mean, how is the defense lawyer supposed to get that information when Miami Herald owns the site?
if you look at some of the screenshots, it's a little hard for me to see. I don't have a color copy. But some of the screenshots are like from the Dallas News, from NBC Today Show. I mean, they're not local. They're not local. And so, Your Honor, I won't belabor the point. I know the state wants to speak as well. The Lewis test has not been met here. And there's no basis for you to grant relief that the defendant seeks. If Your Honor is having more questions, I will.
I do. I have one question. Okay. And what is your client's position, your position, as to the defense's any alternative request for partial dissolution?
Well, I don't know what that means. It sounds like being kind of pregnant.
So she said she only has one question, which can happen in appellate arguments or oral arguments like this during a motion hearing. And she said one question: what do you think about partial blocking of certain evidence? Meaning, you know, both sides agree, okay, this probably shouldn't be leaked to the media. If we disagree, we come before the court and the court can either block it or allow it to go before the media. And then some stuff will be able to be subject to public record so the public can see it, media can see it, and things like that. She wants to know how he feels about that, which indicates to me that's kind of where she's leaning to, is if we can come to some compromise. Miami Herald's like, I don't even know what that means. So I think he still wants to kind of steer clear of that, but we'll see if the state agrees to that or if she asks the state the same question.
I mean, once the defendant gets the materials, they become public records. And the fact that the defendant is showing it to them in a meeting and then taking it back to their office and they're going to talk about it, I think the kind of toothpaste is out of tooth, metaphors here. I think that once it's been seen, that's gone. I mean, it's hard for me, having obviously not seen this and not knowing what's there, it's hard for me to talk about what I don't know. I mean, the defendant made the decision, strategic or otherwise, to come in and ask Your Honor for a prophylactic preemptive relief. Just stop everything from coming out. They could have waited and said, here are the 3 things that we think for whatever reason should not be gone out, and done it in a much more targeted, specific way, but that's not what they did. You know, we're here on day 2 of these hearings. They came with what they came with. They didn't change their approach, I don't think, in the reply. You know, it was their decision to come and request a kind of blanket preemptive relief, and it's just not appropriate. There's no grounds for it. Thank you, Your Honor.
So his response was basically, they first asked for the blanket relief. I don't think you should give it to them. They also decided to come now. They could have waited till they had more information, and they didn't. But in reality, the defense is trying to, as he said, the opposite of what he said, keep the toothpaste in the tube. T.S. Duff, we look forward to all of your Lawyer You Know lives as we are still driving coast to coast right now. Awesome. Glad it's safe traveling. We are traveling through the soy and cornfields of Indiana. It is so much more exciting when you are on. Thank you, T.S. Duff. That's very nice. And so you're more than halfway there, I guess, right? Driving coast to coast, literally. Gloria S., I just watched Just Mercy last night based on your recommendation. Great movie. I think all the trials are interesting to see, civil and criminal. How are they supposed to get an unbiased jury? Linda L. says, well, the same way we always try to. During voir dire, we'll talk to them, see if we can find jurors that haven't made up their mind yet, that'll just listen to the evidence and make their decision based on the evidence. Joe Gottman. Question, is this the first step they do before the trial? No, this doesn't happen in every case. Very specific cases have motions like this that are filed. This was a specific motion for this specific case, and the media attention and all the clicks and all of the available information about the defendant is the way I'll put it nicely, make this case unique. And so they filed this motion to try and affect this case specifically. This isn't something that happens in every case. Shelley Carlins, I feel like quoting the law to a judge is slightly insulting at times. Have you ever had a judge snap back saying they know the law? I know there are nuances. No. It is not disrespectful. You have to do it to put it on the record. You have to do it to make your argument. And a lot of times you could potentially explain the law a little bit differently than the judge sees it. The judges are also respectful to the lawyers because a lot of times judges haven't practiced as long as lawyers or as long in specific practice areas. The judge I tried my last case in front of, I don't think I'd ever tried a personal injury trial. So theoretically, I know the law better than her. So I can explain it to her in a way, and then she makes the decision. They are the decision makers. They are the gatekeepers. They analyze the law. They have presided over a lot of these kinds of cases. So I've never had one feel that way. Sometimes I've had them get annoyed if you repeat arguments that are already in the papers. Sometimes they'll get annoyed if you go longer than your agreed upon argument time, things like that, but not quoting the law. They don't usually get upset about that. Pooh Bear. So what is the actual law around releasing this type of evidence pretrial? Exactly what he said. It can't create a miscarriage of justice or be so unfair or taint the jury pool or make it impossible for them to find a fair and impartial jury in their jurisdiction. That's basically it. It's kind of a vague high bar. So we will see how it goes. Let's hear from the state now.
May I please support the open and the state? Mr. Ponster for the Herald has addressed a lot of this in my martial case reduced. First and foremost, just to address that point, the state made an argument about rightness at its written motion, and I did acknowledge that written in our papers that the defendant's motion was not right, but would inevitably be right. And part of the fundamental problem, Mr. Ponster just addressed it in the defendant's motion, is that frankly they do not know what they do not know, and they are asking this court to issue a blanket order preventing the state from complying with state law as part of the executive branch. And that's my segue first to the defendant's reply, because the defendant is operating under rules of judicial administration about court documents. As is clear in their pleadings, for example, the legislature is not subject to public records requests because the legislature has not created laws that apply to them. Chapter 119 is what governs the state of Florida and its obligations to comply. And frankly, normally these issues are contested between the state and Herald, where there are disputes as to what is or is not consented. The problem here is that we are unusually in agreement where a blanket order is not appropriate. And my job as a prosecutor is to be administrative justice and inform the court of that. The defendant's motion is not proper for various reasons. One, it's asking the court to sit in excess of the legislature and say Chapter 119 does not apply because you don't like it. And that's not appropriate. Secondly, and I made this argument about equitable relief, and I think it translates also about the quote-unquote drip. This case became newsworthy because of particularly bloody video that was posted on the news. Instead of remaining silent, the defendant chose to release a public statement on April 8th and released it to local news. A month later, while there was still intrigue, the defendant released another statement to Rolling Stone and Fox News. A month after that, there were more statements. Frankly, it was Mr. Pareto who both informed the press and the state of Ms. Clenny's arrest. He, Mr. Grazo, sent myself and Ms. Hogue an email asking if we had issued an arrest warrant, which at that time was under seal, and frankly, I could have been held in contempt of court had I disclosed it to anyone. And he was the entity that made it known for the state and the press. Again, I had to note I was in contact with the U.S. Marshals in Hawaii, and they had not called me yet because Ms. Clenny was allowed to call her mother before, who relayed the message, I imagine, to Mr. Grazo of her arrest before the state was even aware. It was because Ms. Grazo and the defendant's conduct that, frankly, there is such scrutiny, and as a public office, we are obligated to answer to the public.
So that's going to be one of the worst parts and hardest things to get over. He actually, the defense attorney and the defendant, were making statements to the public. We're living in the media, basically, and now they want to say no. So that is difficult. It is a little bit different, but still, I mean, that's tough. If he would have done nothing and totally stayed out of the media, I think this would be a better argument for them.
As I noted in our papers, the surveillance video that was provided, as much as Mr. Grazo would choose to argue admissibility, I will not go down that rabbit hole. But the simple fact is that is less than 1/4 of 1% of the total discovery in this case. And as Mr. Grazo mentioned about text messages, first it was the victim's phone that was accessed, not the defendant's phone, and that's noted in the discovery exhibits. But there are 12,220 text messages between them alone. For us to sit over those 9,000 pages on the PDF and go line by line with Mr. Grazo to decide what to disclose to the press is not attainable. First,
So that's a good argument. There's so much in this case that we're going to have to go through. And if we're going to have to line by line go through this stuff to see what the press can and can't see, that just makes no sense. That's a waste of resources and time.
because frankly, it would push the state to have to disclose what it will and will not seek to admit in court. Besides that, we have a public records office staffed by 3 attorneys and support staff that go line by line and will be issued with exempted material. So, for example, if the Miami Herald filed a public records request asking all of the text messages, we would reply that's too broad unless you want us to go line by line over 9,000 pages because something specific, and so on and so forth. That is the proper administration of Chapter 119. As it pertains to their motion, I believe it lacks legal merit, both for the reasons I stated, because it's asking this court to exercise its judgment over the legislatures in Chapter 119, but 2, because it completely, on its face, fails to meet any of the requirements. As counsel for the Herald noted, the affidavit does not particularize location, and this is not the first prosecution, one ever made, but 2 of particular scrutiny. And that's both criminal and non-criminal, and I can go on for days about other cases, but I won't. The simple fact is the defendant has failed to meet the burden. They're asking the court to, frankly, allow them to control the narrative. And that's without knowing what the discovery is. More than 90% of cases close out to plea resolutions, and God only knows what this case will ultimately resolve as. But the defendant doesn't even know what they're asking the court to seal. And because of that, the court must deny their motion. It is not right. It is not sufficiently narrowly tailored. And frankly, it's asking the court to do something that is not within the court's authority. And for those reasons, we ask that the court deny their motion on the merits.
Any final words, Mr. Blvd?
Yeah, Judge, I'd like to pick up on counsel for the Herald saying, the toothpaste is out of tube. That's exactly the problem that we have here.
All right, before we get to his rebuttal argument, let's answer a couple more questions. John O'Rourke was arriving a bit late. He was worried the Herald lawyer could give the lawyer a run for his money, speaking that rapidly to the court. Thanks for breaking this down. Is Courtney there? Yes, she is. She is in orange, and we also have this on 1.25 speed, and if you were late, you probably didn't know that. So he did speak pretty quickly, but not quite that quick. Bodie, but how can they prove those things? And those things being that something was bad enough to taint a jury pool. How do you quantify that enough to prove it or make a change because of it? I think if they could have shown that the, 1 million of the 2 million people in their jurisdiction clicked this document and read this on the Miami Herald, I think that would be a pretty good argument. But instead, they have no idea where the clicks were coming from. And again, that'd be very difficult for them to get. Show said, the law is also interpretive, right? That's a big reason why we have judges. That is the reason we have judges, to provide interpretation that will stand during proceedings. And 2 lawyers can read the same case and see it completely differently. And we need a 3rd lawyer that we call a judge to make the decision on to how that case is going to be applied. CMC, do you think it's a genuine concern or they can actually find a good jury pool in that jurisdiction? And, as smart as our chat and community is, this question was answered by Elizabeth Turner. I mean, to be fair, had I not seen the elevator video, I don't think I'd have formed any preliminary impressions. Because of it, I feel a certain way about the case already, so the defense isn't way off. There's your answer. And I feel the same way as Elizabeth. All right, let's hear the rebuttal argument here.
Once the toothpaste comes out of the tube, we can't get it back in. So what the state is arguing, and what the Herald arguing, is saying, hey, just let it all become public record, and then, Mr. Blvd, you and your defense team filter through it and file your objections or motions to seal at that point. At that point, the cat's out of the bag, the toothpaste is out of the tube. We cannot. What will happen is the state will release this under Chapter 119. The media is going to gobble it up in a room full of reporters. Ooh, look what I found. Look at this. And by that time, the defense wouldn't have had an opportunity to have draft a motion, draft some type of protective order, bring it before your honor. That's why we're just trying to preempt the just dump of all these mostly. So, and I take issue with the state saying we know exactly what is evidence in this case. The cell phones, Ms. Clenny produced her content on her cell phone. We know that that is out there. Mr. Obumseli's phone probably had some adult content on there as well. Photos, performances that have absolutely nothing to do with a judging.
Did he say performances?
This is going to turn into a circus of media outlets publishing salacious material that has absolutely nothing to do with guilt or innocence in this case. We can't undo it once it's there, once it's done. And again, the rule of judicial administration talks about a fair, impartial, orderly administration of justice. So the argument by the defense is twofold. To preserve that, plus my client's right to a impartial jury, it's the combination of both. We want this to be orderly. Judge, the release of sexually explicit videos, audios, personal information exchanged between Ms. Clenny, her family, this background noise that we're trying to prevent is why we're here. And, you know, Judge, the state's talking, I washed my hands this morning. They're not unclean. They're clean. They've been clean. To vigorously defend my client, I'm not going to stand back and let her be a punching bag in the media. So any contact that I've had with media outlets has been to push back against a false narrative that's being put out there. And that's well within our right, which is actually why we're here, because then we can craft a protective order that not only keeps the state in check as being a minister of justice as they should be, it prevents the defense from doing the same thing, which I'm happy to do. Something needs to be put in place, Judge, to guarantee my client's right, but also the orderly administration of justice in this forum. Judge, I received, just to talk about the impact of releasing these drips of discovery, I received somebody on August 14th was so impacted by the release of this video that they felt the need to go to my website and click on the ability to send me an email. And it says, sorry, bud, but Courtney is going away for murder. After seeing the earlier video of that elevator, there's no way her self-defense story holds up. She's a psycho piece of rock. I've got, it's not the only one.
That's interesting. I mean, that stuff happens. We know, and we've seen it through this channel. That stuff happens, and people have already made up their minds. So, I mean, that's real, you know, and that's a real life example. And I think the judge, that makes the judge listen. I think this is about as good of an argument as you can make here for this.
But this is the intention of this garden. Somebody felt the need to go and communicate with me directly because of this video. And there is no way that the state or the defense can tell you exactly where all these clicks come from. What we know, the volume is extraordinary. Millions, millions, and millions, which in order to protect the fair administration of justice under the rules of judicial administration, when looking at the future of voir dire, I think a protective order is appropriate. Thank you.
Thank you. Thank you both. Anything further from either side?
Nothing from the state.
Not by the defense, Your Honor.
Thank you both for your persuasive arguments. As I said before, the district has had the opportunity to review all motions filed, including the reply that was provided to the court today. I had an opportunity to review the case law that was cited in the intervener's response to the motion, as well as the declarations and affidavits of both experts. Based on argument presented here, based on the written pleadings, the legal authority, and the declarations respectfully, the motion for protective order and relief is denied. This court finds that although this court may have some discretion pursuant to the judicial administration, this court is bound by legal authority, which is the rule and the three-pronged test. I find that the defense has failed to establish by the preponderance of the evidence that all three prongs of the rule has been established. My ruling is without prejudice. At this time, just for verification, the state has not provided initial discovery, correct?
We filed discovery to the judge, and I've consulted with the public records custodian and
All right. Motion denied. Okay. No surprise there, especially in Florida. We are on the side of giving the public access to the courts. And that's an important thing. And I don't necessarily disagree with that. I think he made some good arguments, but at the point of what the judge said, the judge is correct. Nicole, if things are being released by third parties, like building security and by OnlyFans themselves, why is it on the state for releasing these to the public? Well, it's not, right? The judge would just tell the state that they couldn't release it directly to the media. And that's it. And the judge could try to put a gag order, tell people not to release things. But if we don't know where stuff is coming from and the media gets it and talks about it, or putting a gag order on the media, telling the media, regardless of what you get, you can't publish it, judges can do things like that. But at the very least, they could say, state, don't leak it to the media, which wouldn't be controlling over third parties. The OnlyFans info is already on the internet and downloaded by our subscribers and available to download on websites. So this argument is pointless. Not necessarily, because you don't want, if it's coming directly from the state and the state is telling you what the coroner says and that this video proves it wasn't self-defense, that's different than just downloading something from OnlyFans and posting it somewhere else. Rachel Mills, question: if this case goes to court, will you go to the trial to cover it on certain days? I would say maybe. It's not very far away. If schedule allows, maybe. What can they do if they don't get an impartial jury? They could change venue potentially. Should media be made to keep quiet till the trial starts so it can be more of a fair trial, or can media just do what they want? Media can basically do what they want because it's in the interest of justice and the public, and so the public can know what's going on. So that is always, what's very important in our society. Yeah, glory days. The problem is, so why are people so worried about evidence being shown? If it's relevant, it should be allowed. And sorry, but a video of someone getting punched on the internet is relevant in a murder trial. But they're not saying just relevant evidence. All discovery, very, very much of discovery in every case is not relevant and is not admissible at trial. But if all of us see it in the public and everybody that may become a juror sees all this before the trial, they may make up their mind on things that is not evidence, is not admissible, is not authentic, is not reliable. And that's where the problem lies. That is really the difficulty in all of this case. It seems like most of you, and just let me know in the comment section or in the chat now, you would be in support of not blocking any of the evidence and no gag order. So I guess what I'll call it is, should discovery be public or private in this case, right? Public, if you think it should be public and the media should be able to disseminate it and the state should be able to leak it to the media, or private, meaning should the judge block it? That is basically the question that the judge answered today, and the judge denied it, meaning it will be public. She said it was made without prejudice. So that means if the defense thinks there's something specifically that needs to be blocked and needs to not be public and needs to be private under a protective order or a confidentiality agreement, they can still file a motion for that, have the judge look at it specifically, and the judge may still make a decision to block certain discovery from being public. So it's not totally over, but there will not be a blanket block on discovery, making it all private. And I think the judge made the absolute right decision. And that's the decision usually that's been made in our cases. Now, the only time that it's gone the other way is when the federal government and the FBI are filing those motions and the federal court judge says, get out of here, media. You're not going to get to see anything they don't want you to see. Usually it's dealing with undercover law enforcement officer testimony and things like that. So it's very, very interesting. All right, let me scroll through here. Public. We have 1 private, 2 private, undecided, 3 private, 4 private, 5 private. I'm wondering if any of the privates are actually in the United States or in Florida. So I would say 3 out of about 40 people said private. So the vast majority saying it should be public. And Pooh Bear said everybody's saying public because we all want to see it. I don't think they will sequester this jury, Sue. I really don't. I don't think it's necessary for this, honestly. More publics. Yeah, 1,200 people, only 461 likes. Come on, like the video like Maureen said. Another private here, public, selfishly public. I'd like to see what she sent out after the fact. So, Angela, I think a lot of that could be relevant. I do think that could be relevant. Okay, so Steven is in the U.S. and says private. Chain Reaction says U.S. but not Florida, voted private. Private is GVL Gainesville. Gainesville, yuck. Big Florida State guy here, in case you didn't know. All right. Liked and loaded. Everybody's saying public, only relevant stuff public. So Stephanie kind of would have been with what the defense was asking as a compromise. Like maybe some stuff is, some stuff not. If we have a question, we ask the judge. We don't want the jury deciding the case prior to trial. Yes, Brianna, I don't think anybody wants that. Britt and would say private, but selfishly public. Kate Cross said, yeah, really interesting case. Really interesting hearing. Yeah, not something that happens in every case. So it's always interesting to talk about this stuff. A lot of you sent this to me and told me you wanted me to break it down, and you showed up for it, which is great. Send it to your friends that are interested in this case so they can let me know what they think in the comments as well. Hit that like button on your way out. I have a 4 o'clock appointment I have to get to. I appreciate everybody coming in here. Hopefully I'll see some of you guys at the draft if you join the Fantasy Football League. Yes. How about them Seminoles? Go Noles. Nikes is always a autocorrect that happens to me too, Debbie. Go Noles. We're gonna keep enjoying it as long as it lasts. But yes, thank you everybody for joining us. That's all we've got. I'm out of here.